I know this is a tiny room for me to use this microphone, but I'm doing it for the sake of people online so that they can hear us. Thank you all for coming. My name is Dr. Ryan Whalen. I'm really excited to chair this talk by Professor Chang here. Professor Chang is joining us from the United States of America, where he's a professor at the University of Cincinnati and a visiting professor at the Ohio State University College of Law. And his writings, they really span a broad area, or broad variety of areas, I should say. In antitrust and financial regulation, his scholarship has examined the balance between competition and systemic risk in the derivatives and currency markets. And along with an interdisciplinary team, he's developing new tools for antitrust research through topic modeling, which is, I think, some of the research he's going to share with us today. There are, I think, some folks on Zoom. I hope you can hear me okay. If you do have questions, there's a Q&A box that you should use, and then I will, when we get to the Q&A portion of the talk, I'll send those questions over to Felix. If you're in the room, of course, you can just raise your hand when the Q&A period. Okay, with no further ado, I'll give you the floor, okay?
Thanks so much, Ryan, and thanks for being my commentator. Thank you, Lucina, for inviting me. It's really a pleasure to be here. So this is a project that I've undertaken with Erin McCabe. She's a digital humanist and a data scientist at the University of Cincinnati's Digital Scholarship Center. We're using topic modeling visualizations to see the corpus of every tying case in the US, every federal tying case since the passage of the Sherman Act from 1890 until 2018, to see what the links are among the different topics within the tying corpus. As a matter of doctrine, tying is notoriously convoluted in antitrust. So tying is a scheme that links two separate products, and where the producer has sufficient market power in the tying product market or the market for the desired product, and the tying scheme affects a quote not insubstantial amount of commerce in the tied product market, then it will be condemned under the Sherman Act and the Clayton Act. Some different courts will explicitly add a couple of other elements depending on how broadly or narrowly they construe tying is a course of action. It's governed under a quasi per se standard, which would condemn a tying scheme if the producer holds market power in the tying product market. This standard is routinely criticized by a variety of antitrust legal scholars and economists who say that the standard is wrong on both law and economics. So what I'll do for the talk, I'm assuming that maybe the audience is a little bit generalist. I'll spend kind of some time introducing topic modeling as well and talking about the methodology. So topic modeling is this algorithm that maps the statistical relationship among words in a corpus of documents. So for our purposes, the documents are comprised of tying decisions. And every federal tying decision since the passage of the Sherman Act. With a substantial grant from the Andrew W. Mellon Foundation of $2 million, the Digital Scholarship Center at the University of Cincinnati, they partnered with different units. They've developed this topic modeling visualization platform. They partnered with different units to use different data sets to run topic models to answer a variety of questions like to look at pain indicators in medicine, citations among authors in biology cases, and you can actually do topic modeling also in visual data sets. So there's an archaeologist who's come up with a lot of visualizations, a lot of imagery of archaeological dig sites to see the placement of bone. In my talk today, I'm going to introduce you a little bit to the topic modeling platform and work through some of the preliminary findings that we've got from the tying corpus. There are many dimensions of the talk that I'm happy to explore. We can get into the nitty-gritty of antitrust, of the doctrine, talk more about the methodology. I can even talk about the travails of getting grants funded interdisciplinary research. Let me begin with an overview of some of the obstacles traditionally to big data legal research. So one of the obstacles traditionally has been that there's a lack of easily accessible data. Until the last couple of years, it was really difficult to extract a large amount of case law. When we had started the project 3 years ago, we spent 9 months negotiating licenses with Lexis and Westlaw. And these academic licenses were really, really difficult to negotiate. But then the Case Law Access Project came online. It's this collaboration of Harvard Law Library, the Klein Center, and Ravel, which is this legal tech startup. Very quickly, then I'll introduce you to the Case Law Access Project. It's very easy to remember. Its URL is case.law. This is the Harvard Case Law Access Project. It's really been a boon to legal researchers. They've digitized almost every decision in almost every US jurisdiction. So it's almost 7 million unique cases. For those who are interested in federal cases, there's almost 2 million unique federal cases. There's some really interesting capabilities that you have. They have a rudimentary historical trends function that I won't show, but in the Case Law Access Project, you could do search terms, you could do like for federal courts, you could look at the instances of certain terms. Sometimes I'll look at like antitrust tying or antitrust litigation to see what the proportion is of the entire corpus of the decision that you can see over time. So the Case Law Access Project makes it really, really easy for law scholars to download cases in bulk. We had extracted from the Case Law Access Project 35,000 federal antitrust cases. So that's every federal case with the word antitrust in it. It's a corpus of 35,000 cases. For this project in particular, we further filtered it down so that we're running search terms of antitrust plus time. It gets us a corpus of 1,485 cases. We've also extracted every federal case with the word regulation in it. Some of my prior projects have looked at the balance between antitrust and regulation. And if you look at every federal case with the word regulation in it, that's 306,000 cases. The second problem with some of this big data projects is one of modeling. So it can be difficult to translate models into visualizations that audiences can intuitively grasp, especially audiences without a whole lot of empirical training. And I count myself as among that audience. A lot of the work that's been done in the subfield of computational legal analysis has been about whether and how you can model legal reasoning. And that's the subject of a lot of papers in this group, the online workshops for computational legal analysis. And Mike Livermore out of UVA runs this group. It's a really great community. So in this series of papers, we're introducing topic modeling and the variation of topic modeling that DSC has come up with. So topic modeling has been around for several decades already. Topic modeling, again, is this algorithm that illustrates the probability of distribution of terms and their co-occurrences within a data set. It is a process that will help uncover hidden or latent patterns that you just can't see if you're doing close readings of legal text. The prevailing algorithm for topic modeling is LDA. It was used earlier on in early generations of topic modeling, things like the Stanford dissertation browser. It's been used to recommend academic articles across scientific doctrines, and it's really good at breaking down disciplinary silos. So one of the topic modeling visualizations, one subset that DSC had come up with, it's already been adapted from these publicly available topic modeling algorithms. So this one in particular is devised by the digital humanist scholar Andrew Goldstone. And so this is the topic browser view. So in the platform, this is one of the kind of the early set of papers we were playing with was looking at variations of topic modeling devised by Andrew Goldstone. So here you can see the different breakdown of topics. And again, remember that a topic is comprised of the top terms that are most likely to co-occur. That in turn is going to comprise a topic. So in earlier work, we've been particularly interested at kind of the ebbs and flows of topics over time. You can see that over time. The platform that DSD has built has it so that you can look up a topic and then look up the terms. If you, for instance, click on conspiracy, it'll show you the term conspiracy, and antitrust conspiracy occurs very frequently. So the different topics that this occurs at. One of the other things that DSC had done was there's this way of viewing this where you can look at the differences over time more clearly. So what we found over time in some of the different corpora, we have this corpus of antitrust cases that look at market power, and also antitrust and regulation cases. Some of the things that you see over time is the increasing importance and prominence of procedure-related antitrust cases. So particular things related to class action. And oftentimes over time, you see this corresponding decrease in a lot of topics related to old manufacturing and old industries. Not altogether surprising. Well, one of the things that DSC has done that's perhaps most methodologically useful is it's begun to aggregate models. So this is the multi-level or model of models visualization. So this aggregates 6 different models from LDA so that you get modeling that's more stable. You get modeling where you can get hierarchies where the topics are now clustered into topic clusters. So for instance, this is a large topic cluster where the top terms are dealers, tied, dealers, and franchise, and then you can see the constituent topics here. This gives you this hierarchical view. So this is really good because it responds to a lot of the early criticisms of this type of computational legal analysis, which is what some of the critics have said from digital humanities is that you're really counting words, you're really splicing terms, really heavily decontextualized, and it tells you really nothing. Well, what multi-level visualization does is because it aggregates up to 6 different models, it sets this in larger macro context. So again, you see this hierarchy where you see the topics clustered into topic clusters. At the same time, there's a really useful document retrieval function where you can see the top decision within a topic so that you can go in through the decision and then read this to make sure as a backend check that it coheres, that it really does make sense that these decisions fall into these topics or topic clusters. Okay, and maybe what I'll do in the last set of, the last thing that I wanted to talk about was the methodology that we've embraced is from the social sciences, and it's most clearly illustrated in network view. So this is the network view in multi-level view, and the model of models visualization, where you see the topics and topic clusters strewn across a 2-dimensional vector space. Here, the spatial difference you see between the topics illustrates their semantic difference. So therefore, if you have, this is a really prominent class actions and dealers topic. Here, you see it's really, really far from like this patent cluster or this clustering of patent cases. And that shows that they're semantically very different. That's something that we would expect. The vocabulary or the top terms you would see in patent time decision should be very, very different than the vocabulary or top terminologies you'd see in, franchise cases or dealer cases. Well, in the last stage of the talk, I wanted to introduce you the approach that we've adopted from Mark Branaventer's The Strength of Weak Ties. So this is borrowed from sociology, this is the social sciences. This is one of the most influential theories from the social sciences, apparently ever. So the strength of weak ties says that if you take any network, like a social network, focus not on the strong ties. So in a social network, the strong ties will be close familiar relationships, your relationships among close friends, but the network is really going to be held up by the weak ties, that is, more distant social relationships. And the weak ties really do a lot to uphold the integrity and the coherence of the entire network. So the strength of weak ties has been adapted into a number of settings, and recently some examples include LinkedIn. So the social networking site LinkedIn ran an experiment on all its users. Unbeknownst to the users, they ran experiments on 20 million different users. And what they found was that what's most useful securing users' jobs, it's not your direct ties that are your strong ties, but it's your peripheral ties. It's the weak ties that are really more useful than strong ties securing jobs. Another application is that during the pandemic, it became apparent that it wasn't your strong ties that really influence mental health, but it's your weaker ties. So, during the pandemic, you spent a lot of time with your family, perhaps a little bit too much time, but really for your mental health, what a lot of psychologists found was that it's the weaker ties, ties among your coworkers and with your students that's really, really influential in upholding your mental health. I think in biology too, if you look at interspecies links and symbiosis, that's really important as well. So what does that mean for the corpus of time cases? Well, this is the corpus of time cases that we see, and this is how you can look and focus in on the weaker ties. So there's this document link function that's been built in on the platform where you can scroll and scroll to the left, and the further you scroll, you see the limit that shows you the fewer cases or the fewer documents or the fewer decisions that link the disparate topics. And so if you scroll all the way to the left, where like the ties that are shared are say just 22 decisions. If you go down to 9, you see this network become very apparent where you see all the different intercluster connections. What Aaron and I are particularly interested in is the first set of connections that emerge among interclusters. So that is not within a cluster. So these are the clusters are color coded. Again, the clusters are more apparent if you look at the tree view. This is the cluster. These are the topics. We're interested in the first set of ties that emerge across clusters between topics. And you can see that more clearly in the network view if you begin to scroll this way. So in the time corpus, if you scroll far enough, this is where the first set of connections appear. So one of the first connections, for instance, appears here between this topic in cluster 1, whose top terms are class, bank, plaintiffs, franchise, and members, and then this topic here, whose top terms are dealers, tied dealer parts, say, saving per se. And the reason we're particularly interested in these is borrowing from the strength of weak ties theorem, we're really interested in seeing like what are the first set of intercluster connections that appear? What are the antitrust decisions, the antitrust tying decisions that are shared by these topics across the topic clusters? And some of the preliminary findings that we discovered, I'll just, in my perhaps remaining time, I'll highlight 2 of them. The first is that the tying corpus, again, that's every federal case with the terms tying and antitrust. The corpus is really, really loosely held. So if you look at, this is the fancy term for this is edge weight. The edge is these ties that emerge between the topics, and the weight is the number of documents that have to be shared for the tie to become visible. So the edge weights are far lower in the tying corpus than they are in other antitrust code 4 that we've explored. So for instance, you see some of the first intercluster ties emerge at document count around 112. This is roughly 10% of the total document set. So the total document set is about 1,500 cases. By contrast, looking at, this is the antitrust interregulation subset. If you begin to play with the document link, some of the first intercluster connections begin at roughly 50% of the corpus. So roughly at documents that are shared at around 1,100, which is about half of the entire corpus. And these, I can talk a little bit more about how we filter, because there are certain terms called stop terms that we've excluded so that the visualization we think are a little bit clearer. But that's about roughly half, where you can begin to see the first emergence of the intercluster connection. This is an antitrust and market power corpus. So we're looking at every antitrust case, market power. Market power in antitrust is again notoriously difficult to square. Playing with this document link, you see that some of the first intercluster connections begin again at roughly half of the corpus. So by contrast, time is a lot weaker. And so you have to really scroll quite a bit further to the left. And this is far under 10% to see, the emergence of the links where they begin to appear among the topics that are really, really disparate. So what does that say? It says that this is a really, really disparate data set, and we're only beginning to dig in to find out why. Why is it? Part of it perhaps is just that there's not a lot of maybe reasoning by analysis, reasoning by analogy when it comes to perhaps time cases. Maybe you're not doing a whole bunch of analogous reasoning when you're looking at patent tying cases versus like franchise tying cases. That might be part of it. The other result that we see is that class actions play an outsized role. So some of the first inter-cluster linkages between topics emerge here, where you've got a class, where you've got this cluster. It is dominated mainly by franchises. Then you have this cluster. It's a lot of dealer cases. Many of these are going to be franchise cases. Many of these are class actions. Many of these are franchise class actions. And so I think what that means doctrinally is that the fact that you have a lot of franchise class actions in the corpus, that oftentimes is going to drive the doctrine toward legal issues that are more germane to class action certification. When it comes then to time, oftentimes you're going to focus on narrower issues such as like when you're trying to certify a class action against a franchise or against a franchisor, like are there common issues across the class? Do you have to find common issues of say coercion on the part of the franchise and the franchisee, or can you look at individualized instances of coercion? So I think the dominance of class actions oftentimes is going to distill your inquiry when it comes to time into narrower issues that are more germane to class action, and then you don't really resolve a lot of core doctrinal ambiguities. Perhaps the last thing that I'll say is that I'll just end with, I think this is really interesting because it's really colored my analysis of what precedent is and what like good precedent is. So, when it comes to topic modeling, the notion of like decisions that are really influential, is it the traditional analysis, which is like, let's do a citation count analysis to see how influential it is. When it comes to antitrust and time, the most influential cases are these key Supreme Court decisions, but many of the Supreme Court cases don't make it at the topic level. So you look here, it's really hard to see. Perhaps tree view is a little bit better, but you don't see case names make it at the topic or even the cluster level. The exceptions are Microsoft. So Microsoft is oftentimes here. I think Kodak makes an appearance as well. Yeah, you see Kodak right here. Microsoft, these are two big antitrust time decisions. Other than that, you don't see like a lot of other decisions making themselves, they don't percolate up to the top. Not Jefferson Parish, soon Kodak does come up. Some of the older cases do come up. This is perhaps more inside baseball among antitrust scholars, but like Northern Pacific comes up, International Salt. Some of these are older cases, which perhaps takes a more per se view of time, perhaps to the chagrin of more contemporary views of time. But I think I'll pause here and see the floor to Ryan. Happy to answer any questions.
Okay, thank you so much. If you are online, I remind you to use the Q&A box, and I'll turn there in a moment, and I'll give everyone here some time to think up your questions. And in the meantime, I'll make a couple of points myself because I really like this project, and I'm happy that I was invited to chair. So I'm going to use chair's prerogative here. So I'm lucky enough that one of my PhD advisors was one of Mark Granovetter's students, actually. So I'm two steps removed from Granovetter, and I still write with Brian pretty frequently, and I do a lot of network analysis and NLP in my own work. So I really like that you're engaging with this. So what I'm going to do, because I don't really do competition law and I don't know a lot about timing, I did take antitrust in law school, but that's the last time I thought about it, is I'll make two sort of methodological points or suggestions, quasi-questions, and then one that's a little more theoretically motivated. So the first methods point is kind of a recommendation to help you demonstrate your findings. And that is, with any of these network approaches, it's difficult for us to know what's kind of significant and what's insignificant, right? So at one point you say this is a disparate network, things are really far apart. But without some prior baseline or a null model, it's difficult for a reader or an audience member to know really, what is a disparate network? What does that mean? Is there some measure of statistical significance you can give us for that? And so one way to go about that is to actually maybe more systematically try to produce a null model or an empirical baseline that you could then compare this with. You start to do this in the project already by looking at some other sub corpora, I guess, of antitrust. And so just doing some stats on that would help push the point home that this is particularly disparate in terms of these corpora. The second point is maybe a little bit more nuanced in terms of the methods, but here, so to help explain what's going on here, because it's really quite clever, is you're discretizing the data using LDA, which is putting things into discrete categorical buckets, and then basically counting the overlap between those buckets, because not everything is in one bucket, right? You're in multiple buckets, and using the overlap to then go from a discrete measure to a continuous measure. So we've taken text data, discretized it, and then gone back to a continuous measure of similarity, which is interesting, but I think maybe it's not necessary. So you could do the discretization with some sort of topic modeling approach, but then if you really want to see whether or not the cases in patent antitrust tying cases are similar to the franchising ones, you could do a text embedding approach. And I think that would give you maybe a better measure of the similarity between these different topical buckets than just looking at the overlap in LDA, because the LDA topical overlap is problematic for a few reasons. The topics load quite early in the vector, so the trailing end of the topical distribution is really usually quite weak. So it depends on how you discretize and how many topics you allow your documents to be assigned to, and a lot can vary based on those decisions. So the embedding approach might give you a better metric. So those are kind of some methodological suggestions. One question I had was about the strength of weak ties and this theoretical hook that you've used, and I think it's really interesting. So the strength of weak ties essentially is a theory that says, people you don't know very well are sources of good information because they know things that you don't know. They have access to parts of the network that you don't have access to, right? So they might be in the canonical work, good people to go to find a job because they know of opportunities that you don't already know about. And I wonder how that maps to a doctrinal semantic network, and if there's a way you can use your methods to help support your contention that the weak ties are important here. And one way you might be able to do that is using citations, right? So you might be able to look at whether or not the influence or doctrinal influence within these networks is traceable via a citation network that maps to the weakness of the semantic networks, which is to say, basically, if two buckets are weakly semantically linked, are they more likely to have important citation references? And that would be a really interesting theoretical finding. I think that would be a really cool demonstration of why this kind of approach works. So, I mean, in your defense, that's not a question either. That's, again, another comment, but I'll give you a moment to respond, and then I'll turn to the audience for Q&A.
Yeah, thank you, Ryan. This is all really terrific. And so I think maybe the one thing that I wanted to focus on was thinking about the doctrinal influence. So, I've been thinking about that quite a bit. What Ryan and I are talking about is just thinking about the strength of weak ties and what it says about doctrinal influence. And so if we can do like, a citation network. So I just been thinking about that because I think when you go and when you go and you're a clerk or you're a judge and you write an opinion, I wonder. So I do wonder if the natural reflexive thing to do is to cite all of these decisions that people are going to cite anyway for a variety of propositions when maybe you might have read all these other decisions that don't show up. And so that's the thing that I'm noodling through right now. And I was wondering then if the strength of weak ties can show you, because this doesn't look at citations, right? So this doesn't look at citations. And so I was wondering then if what this shows is like, the semantic, the vocabulary that you're employing to think through, is there a tie, is there not a tie, is it per se illegal, is it per se, are there efficiencies? If that might be informed by decisions that the judge or the clerks might have read, but they're saying, I don't know, if I cite this lower court decision in another jurisdiction, it's not all that persuasive. I'm going out on a limb anyway. I might as well cite all of these traditional decisions. So that's the thing that I'm thinking through right now, but that's really helpful. Thank you.
Thank you. Any questions from the floor or online? Yes.
Thank you, Felix, for a fascinating talk. I mean, I'm completely ignorant about the methodology as well as antitrust law, and I just have two questions, and pardon me for my ignorance. And because, as you said, and as I understand it, and your model is very much is based on semantic statistics, and connections between the vocabularies that are used. And I was just wondering, therefore, and if there are any confounding factors that might affect the statistics, such as, for example, some judgments may be longer, the judges may be more verbose, or that there might be multiplicity of actions over the same breach by a certain company, so that even though it pops up a lot, actually ultimately there's just one issue or one decision ultimately. And I wondered what filters or what techniques you use to filter out these factors.
Yeah, thanks for that, and all of those are confounding factors. So some cases longer, some cases shorter, the repeat action, the fact that these are decisions, you can have a case, multiple levels, they're all going to show up. All of those are. The other thing is that because this is a body of cases. Part of it might be it's weighted towards some older cases, so the older cases might be. I don't know, in terms of the relevance, the relevance is a little bit different than what lawyers are trained to think of as relevance. We're trained again to think of relevance, from a citation paradigm, but the relevance here is more statistical. But that might cloud the modeling as well. So some of the filtering techniques we've done where we use these stop words. So whenever we run visualizations on a corpus, to begin with, we don't run it with any stop words. So we just have the keywords that'll be like antitrust and market power, antitrust and time. Because it's really informative, just to make sure that at first it was always bewildering. We'd see like high recurrences in terms like court, law, plaintiff, defendant, circuit, supra, all of this stuff is stuff that we'd see. But then the data scientists that I've heard with said that's a good thing because it shows that the model is doing something right. These are terms that you would kind of expect to percolate at the top. So one of the ways we try to get at this problem is over time to filter out stop words, but with these unsupervised machine learning, you don't want to play too heavy a hand, and so that's a balance that we have oftentimes struck. The other thing that's kind of tangentially germane to your question that we've tried to do is when we run a search, we're now beginning to look at them across to filter them by decades. So rather than just doing antitrust in time from 1890 to 2018, we're looking at them through the decades just to see how much variance that is, just to make sure that the models that it kind of makes sense, just to see kind of some of the variation. Because when you have the visualization, how you see the corpus is really important. That can get you a really broad variance. I'll say.
Other questions? Yes.
Use this modeling to open access to softer areas of law. So I'm doing a lot of research on bailiff activities and paid advocacy and issues that don't get the big cases.
Yeah.
And one of the big things that we struggle with is we just don't have access to the information because they're being
Yeah.
dealt with in small claims courts.
Right.
That don't need records or ombudsman or kind of they're being dealt with on the bailiff basis, and you don't have to understand the legal issue behind them. And this provides a really unique opportunity to open up these areas of law that we often as lawyers don't know much about, but it's the kind of financial advisors and the citizen fight group law and grounds that understand. So is there any way to kind of filter that down to the internet as well?
Yeah, it's mainly in the data sets that you extract. And so if you have the data set, if you have a large enough data set, you can do this. And so some legal scholars, Mike Livermore at Virginia, he's an environmental administrative law scholar. He looks at a lot of environmental notice and comment just to see, and he's run topic models on those. Some other folks in computational legal analysis have looked at judicial style to see how judges, the variances across judicial styles. In finance, some people I believe are beginning to run models on, say, securities filings, like your annual reports, quarterly reports. Call centers do a lot of this stuff. So call centers, when they have transcripts of the calls, they'll run topic models to see what are the current issues that are percolating up that we have to address right away. And I'm sure there are people on Wall Street who are running like models on like Federal Reserve statements or any sort of like regulatory filings. Oh, and the other things that I'll say is that this is really weighted toward decisions. These are published opinions. So there's a large part that's not captured, which is like settlement, things that never make their way into a decision. And that's something that we recognize. it could be that tying is just really difficult. It's really hard for judges to get right. And so when you're litigating tying, you're rolling the dice. And maybe then two parties, when they get close, when they get close to trial or they pass summary judgment, that the incentive is going to be greater to settle. So this is not a project that captures that. Some of the older empirical projects, in 1982, there was George Sherman, antitrust litigation scholar, Steve Caselaw, and a couple of other folks, looked at a lot of antitrust data set. They had a hand code, a lot of them were settled. So in that way, you can see more, the data set is a lot more variegated, but here we admit that it's really published judicial decisions.
Okay, thank you. Other questions? Yes.
Thank you, Felix, for this very interesting presentation. So I just looking through the keywords, notice that some of these are facts or subject matter disputes, and some of these might be legal issues. So I just wonder, do you see any point in separating the legal issues with facts, or is it always not more of them?
You mean in terms of our search terms, right?
Yeah.
In terms of the stop words.
They're not stop, but the keywords.
The keywords. Yeah, so the keywords here is terms antitrust and tying. And so we've done 3 different antitrust corpora. One is antitrust in market power, one is antitrust in regulation, and then now it's antitrust in tying. And my thinking to do this was to look at things that are really doctrinally difficult. So like market power. So market power is notoriously difficult in antitrust to get right. So it was motivated more by the doctrinal ambiguities than anything else, is to see if this type of analysis can help. And that truthfully, I mean, the draft that I shared, that's kind of the way that I framed this, which is like, times is really difficult. Both there's the Chicago school and the Harvard school. Both of them don't quite like the quasi per se approach. They're kind of unified in saying that maybe time should be quasi per se illegal. And so what I thought was, wouldn't it be lovely if we did this and we could resolve that dispute? I think that was far too ambitious. I think that framing is something perhaps in the next iteration I'll just get rid of. But yeah, what's driven my choice of the terms is to look at within antitrust doctrinally difficult areas of antitrust to see if to shed any light.
Thank you. Other questions? I'll add a follow-up question if I can. So I really like the project so far. I'd like to know where you think you're going to take it next.
Yeah.
I'm curious.
Yeah. This is part of the difficulty of grant-funded empirical research. We had a $2 million grant. This was based out of the library system at the University of Cincinnati. They are not renewing their commitment, and so it's really unfortunate. But it looks like maybe the core group of data scientists might have to disband. I think they're going to find another home somewhere. And so what I had hoped was to have this as a tool for antitrust scholars, to have this open access, and that you could just look and you can play with the visualizations. That's ultimately where I was aiming for. We still have some hurdles to get there. We're constrained by server space. The models take a little while to upload. But my ambition was to have this as a tool for our community of scholars. It's just another tool in the arsenal to look at doctrine. But I guess that's the vagaries of not only interdisciplinary research, but also depending on grants. And it's unfortunate. I guess one of the things that I'll say is that, within digital humanities, one of the criticisms that in here is that, you're bringing like these quantitative and computational methods into fields that traditionally had done fine with close readings, and you're now kind of making the university model much more neoliberal. You're having to chase down grants, and a lot of people don't really like that. And so I don't really have anything that's helpful to speak to that. I do think that this is a novel approach that does have some merit, and I'm not a complete skeptic, because a lot of what skeptics will say is they'll say you're just counting. This is just fancy counting. So like some of the earlier generations is corpus linguistics, which is well, if you want to like do statutory interpretation, let's just count like recurrences of terms. If you're saying that statutory interpretation has to track plain English, let's just see how terms within the corpus of Google or whatever. Let's just do count. I don't think this is quite like that. I think that the methodology is a little bit more sophisticated, but this isn't easy work and it's expensive. I guess the other thing that I'm heading toward is what I would like to see is the privacy of Westlaw and Lexis challenged. I don't think they're entirely transparent. Susan Neville Omar, who's a law librarian at Colorado, has run searches before on 6 different legal databases and oftentimes gets 6 different results. I don't like the lock as an antitrust person. I don't like the lock that the incumbents have, that Lexis and Westlaw have on legal research, high barrier to entry. I guess the good news is that today that there's legal texts that are coming online promising bigger, better, faster, more nuanced analysis. We'll have to hold them to account, of course. My hope is that we're being very transparent with the methodology. Will force Lexis and Westlaw to be more transparent with their algorithms.
Great point.
That's just one final question, but it's probably completely unrelated to what you said, because based on what you said and lack of funding and all that, do you see any use that chat GPT plugins?
So yeah, technically is a hot topic of the day, and I'll pivot. I'll just deflect and say that I'm not familiar enough with ChatGPT. I don't, for now, see ChatGPT able to this kind of sophisticated analysis. I don't know. What do you think, Mike? I don't think so.
I think you're right. It can help you write your code. It's actually quite
Yeah,
good with that. I
right.
use it when I'm teaching data science. It helps the students quite a bit, but it can't spin up anything like this from scratch. You still need a human.
Felix, do you think that the results you have thus far, even you can't bring it any further because you need more grants?
Yeah.
Do you think that this would help scholars in the different fields kind of conceptualize, their research from a qualitative perspective? And this may not be totally related because I'll speak more about this during my lecture. But it was interesting because speaking from the judicial perspective, when we have novel cases, we tend really to look, because as you know, a lot of common law activity is really reasoning by analogy. So if you have a novel case for which you don't have any direct precedents, you really be looking across jurisdictions and maybe across fields for principle. Whether or not you can extract a principle that will help you, decide your case at hand, even though it's different subject matter. And I can see a lot of possible application. It's very easy for a non-expert. I don't know anything about topic modeling. But I'm just thinking from if you had the funds, because it's hard work, and it takes time. But for me, from a logical perspective, if you had the funds, and I think I don't understand the lingo. I'm a dinosaur, but I'm working from first principles because that's what we do in court, because in court we don't have domain knowledge of every area. So sometimes you just have to work from first principles. I think you mentioned embedded.
Text embedded.
Text. Yeah, if you could. It seems to me that I may be wrong, so correct me if I'm wrong, that this is kind of like a follow-up. In other words, what you're doing is you have these terms first, but if you had the time and the funds and the opportunities, you could actually, what I would say from a dinosaur point of view, drill deeper for more, and then get more nuanced results, which in turn then would help scholars, who are working in the doctrine fields and are trying to develop the doctrine.
Yeah, so thank you for that, Judge Fong. Thank you for that question. I think that the qualitative aspect is really important, and that's not something that I've emphasized, but the qualitative aspect is really helpful. We know that in law we reason by analogy, and that's what's often done. And so to give you a very concrete example here, when you look at this topic, so an example of why the qualitative is really important is that DSC will say that we can build a platform for you. We can show you the ties, but it really takes a subject matter expert to bring this to life. So here's an example. In this topic, you see all these cases, and bank comes up as a top term. For the antitrust scholar who knows about time and bank time, that's really counterintuitive because tying is an action under the Sherman Act and under the Clayton Act, but you have bank tying as well. There is a set of amendments in 1970. This 1970 amendments to the Bank Holding Company Act gives you a cause of action under banking regulation for tying. And there the elements are slightly different because in banking, the drafters had said that we're going to presume market power when it comes to credit. So tying in the banking context is like, look, is it illegal to tie these additional products if you're extending credit? Basically, you're extending loan. Well, again, because loans, you presume market power, whereas normally in tying cases, a lot of the analysis is what's the degree of market power and the desire for tying product market. Why is it that in this topic, you see franchise cases, you see bank tying cases? Here's a well-known bank tying case, Thibodeau, Louisiana. It's a Fifth Circuit tying case under the Bank Holding Company Act. Some of these cases don't proceed under the Bank Holding Company Act. Why is that? Even in bank tying cases, oftentimes they're going to borrow the analogy from antitrust tying. And so why is that when it's not as a matter of, I guess, for bank tying and statutory interpretation, that's not proper. So I think that's the type of qualitative analysis that a subject matter expert can bring to bear. It's really important.
But
I just had a final comment. It's a radio question. It's a disciplinary study. I wonder whether your type of actually tackles some of the underlying discussions or the underlying discussion. So as the paradigms of the I think it's perspective or sometimes a lot of justification or a lot of trust is based on very simple stories of the power or bicycle.
Yeah.
But then when you actually look at the cases, they are not of that kind of stories, and that might actually change how people
Yeah, so in all these time corpora, what you see is oftentimes the cluster, they splinter among industries. So, it tends to be that, I guess that's helpful, and that's in one respect not unexpected that time cases or market power cases, oftentimes you see like a banking securities cluster, insurance cluster, healthcare, class actions. I guess that makes sense, but semantically, is it that in these types of cases that you're using certain vocabulary so that maybe the doctrine is not as important? I'm not sure. The other thing that I think that it kind of vitiates our underlying assumptions is just, again, thinking through doctrine. So, like, what does it mean that the most important cases aren't really coming to prominence? When you look at the edges in the cases that are commonly shared, there are some Supreme Court cases. Fortner is a big time case that makes its way here. And again, Microsoft, Kodak. Beyond that, it's not a whole bunch of these canonical cases. Many of the cases that are shared are like small district court cases. When I look them up on Lexis and Westlaw, they're well cited within their jurisdiction, but they're not thought to be, precedentially important. So that's something that I'm working through as well. Like, does it really revise our notions, and should it revise our notions of precedent? And also the other thing is that with these tools coming online, should we be teaching legal research and writing in different ways today?
So what's the potential? I'm just thinking aloud, because this is quite fascinating. What's the potential for costs being reduced to the extent that you could do this?
Yeah.
Cost-effective basis?
There are services and websites out there. One of them is bigml.com, like big machine learning. At least a couple of years ago, is doing a lot of free machine learning analysis for academics. I think the barriers to entry are declining. You still have to build something like this. You can take other people's algorithms. I think some of the barriers to entry, they'll decline as a matter of cost. You still do need data scientists and digital humanists who know what they're doing. So that's some of the costs. Just because the back end check. So one of the things I didn't talk about was like, how do you make sure that this makes sense? Like, what are your robustness checks? And one of the things that we've done was we ran coherence scores through all of this to make sure that semantically the topics kind of cohere. So I think that's some of the barriers to entry that will remain.
Yeah, but all it takes time and cost. I mean, it costs.
Yeah, it's getting cheaper and cheaper to do this.
Okay, I think that's encouraging.
Yeah.
I mean, not for my generation. We are passé. But this is the future. I mean, 23 years ago when SMU first started, as a business school. I mean, we were talking on the way, chatting on the way up.
Yeah.
I mean, to me, this was the way for the future. And you don't need to be an expert to realize what the reality is.
Any final question? No? Okay, well, I'll just say that this is a really good example of the strength of weak ties between disciplines, because you right now are a weak tie between the data science and the law people, and it's a really valuable, right? Because you're translating information between both fields. So I'll thank Felix.